Good morning. I'm Paul Truster, head of CLE for the Law Society. I'd like to welcome you to the first annual Civil Litigation Forum. A good many of today's registrants have yet to arrive and doubtless will be arriving over the next hour or so, but I don't want to hold us back any longer. You all have a set of materials, and I want to draw your attention to a couple of features. A few papers, as you see, were printed late and they've been handed out with the binder. There is, however, no paper presently corresponding to tab 4, and we don't know at this stage whether there will be or not. If one arrives during the proceedings today or tomorrow, an announcement will be made. If one is submitted after the fact, it'll be mailed out, and if one is not submitted, then you'll simply have an empty tab 4. You will see some pages into the binder. Well, for one thing, you'll see a number of advertisements for upcoming CLE programs, which you might want to look at your leisure. But just before that, you'll see 2 gray course evaluation forms. And I just wanted to point out that we take these very seriously. These do assist us in planning programming that will best meet your practice needs. And so you would be acting in your own enlightened self-interest, as well as doing us a very great favor if you could complete those forms and leave them at the registration desk outside. There's one for each day. You may wish to complete the first form at the end of the first day, or to complete them both together at the end of the program tomorrow. If you don't have time to complete them today or tomorrow, you're very welcome to fax or mail them in. However they arrive, each one will be read, each one will be considered seriously. I want also to take a moment to thank our chairs and faculty who have given very generously of their time and talents in preparing the materials you have before you and the presentations that you'll be seeing and hearing today and tomorrow. CLE is completely dependent on their efforts and their expertise. We obviously couldn't do a thing without them, and we're extremely grateful for them. As you'll note, there are 2 co-chairs of the program, Wendy Matheson and James Morton. I understand that James will be here this afternoon. Wendy is just seated here at my right in the first row. I'm sure she's very well known to many of you from previous CLE programs, and she's in, of course, practice of civil litigation at Torrey's, and she will open the program. So please join me in welcoming Wendy Matheson. Thanks.
Good morning, everyone. The theme for this morning's first few lectures is a simple one, and that is getting results early. Given the expense of litigation and the protracted nature of litigation, we thought it would be useful to focus on some of the tools that are available to us to try and get some outcomes early on in the process. So the first 3 speeches this morning focus on that topic. I'm pleased to be able to introduce our first speaker, Peter Griffin, who's sitting to my left. Peter is a partner at the firm of Lenzner, Slatt, Royce, Smith, and Griffin. He is a senior and talented litigation lawyer who you may have encountered in practice, both in the commercial litigation area and, as I've come to appreciate in my own interactions with Peter, a talented litigation lawyer in the health area as well. He has a broad practice, and he has to indeed be in court this morning, and we're very grateful for him to come this morning to speak to us before he has to go off to court. He's going to talk about the very thorny question about what's left for us to work with under Rule 20, motions for summary judgment. So I'll turn it over to Peter.
Thank you. Is this getting to the far corners of the room? All right, if it's not, just give me a signal. I have the subject of Rule 20. I can tell you that my motion today is not a Rule 20 motion. I have some severe reservations about how useful a tool it is in the current regime. My paper and what I'm going to talk about particularly focus on a couple of themes. First, that I believe that the ebb and flow of Rule 20 as a useful tool in our jurisprudence has tended to follow the pressures on the judicial system of one type or another. And both the advent of the new language, the current consideration of amendments to that language, and the court's treatment of Rule 20 has reflected some fairly pragmatic pressures. Secondly, Mr. Justice Borens, who seems to figure rather prominently in the debate over Rule 20, tells us that the current mode for dispute resolution under the Rules of Civil Procedure is the plenary trial, and accordingly, Rule 20 should be interpreted in that fashion. I'm not at all convinced that that is either the spirit or the direction of the rules, and I want to touch on that just a little bit as against the length of trials and the cost and inefficiency of the trial as a plenary method of dispute resolution. I want to then make some observations as to where the jurisprudence has left us as practitioners and offer a few thoughts on where we are inevitably going in respect to reform. I'm not sure everybody here was around when the 1985 amendments arrived. Well, certainly not around in the sense that it mattered an awful lot to you. Rule 20 was heralded as a great step forward in our jurisprudence. For those of you who practiced in the era of specially endorsed writs of summonses and the motions for summary judgment that followed on those, it was quite a limited and different jurisdiction with which we dealt. The courts were exceedingly busy in hearing trials. Some of us still remember the scarring that we would take in creeping gingerly into Mr. Justice Holland's assignment court and giving the bad news to our principals that they were on tomorrow despite our best efforts. There was a huge backlog in the trial process, and I believe that Rule 20, along with the spirit of a number of amendments to the rules which came along with the new Rules of Civil Procedure, essentially reflected an attempt to get cases out of the system that didn't belong there. And I think the high watermark of that jurisprudence was probably the Pizza case, Pizza versus Gillespie, which I haven't referred to in my material, but I went back to have a read of it the other day just to entertain myself as to where we once were as opposed to where we are now. It's a fascinating case because what Mr. Justice Henry did in that case, which was a fight over a non-competition covenant between Mr. Gillespie, a former officer of Pizza, and the Pizza organization, because up popped, God bless it, Chicken. And that prompted more than a little annoyance in the Pizza circles because it, other than the critter that was used to manufacture the product, it bore a striking resemblance to the method that Pizza carried on business. So short of the feathers, there was a real similarity. And that led to an action which was brought against all and sundry, and a motion for summary judgment was brought. And Mr. Justice Henry did something that I did in preparing my paper. He took all of the cases in his case at the outset of Rule 20 and lined them up in a row and followed the evolution and came to certain conclusions. I did it the other way around. I followed the devolution to the point that I think that it's relatively a sterilized tool as against the provisions of Rule 1. At any rate, he had some interesting observations, and perhaps I can just share them with you for a moment. He said that Rule 20 contemplates a radically new attitude to motions for judgment. The objective is to screen out claims that, in the opinion of the court, based on evidence furnished as directed by the rule, ought not to proceed to trial because they cannot survive the good hard look. He went on to say you've got to put your best evidence forward. And then he said apparent factual conflict in evidence does not end the inquiry. The court may look at the overall credibility of the plaintiff's action. Does it have the ring of truth about it that would justify consideration by the trier of fact? And may, on a common sense basis, draw inferences from the evidence. Matters of credibility should go to trial, but they should have a hard look. In essence, the court really has to weigh whether it's a real issue or not. Now, some of those principles pervade the cases that come along later, especially from the Court of Appeal. But the spirit of that case is very much different than the spirit of the rule as it's presently interpreted. And I think all of us, as a result of that decision, tended to bring these kinds of motions on, even when there was a fair amount of paper involved, and try and get to an early resolution of the case. And I think it led to an increase in the rule, and a dramatic increase in the rule in the period since 1990 until we hit what I call some turbulence in 1998. And it was useful because it was avoiding what we all see, which is every trial is getting longer and more complex. There are more issues that tend to be dealt with. There's more law, there's more documents, there are more witnesses, the witnesses are longer, and the day of the 2 or 3 or 4 day trial as a plenary method of dispute resolution is virtually gone. There are very few cases that fall into that category. And I think we were all starting to feel a little bit smug. We were having some pretty good success in bashing cases out. Limitation periods, even discoverability, we were knocking out, and we were starting to strut around feeling pretty good. And the courts would generally tend to grant summary judgment, except where there was a real head-to-head fight on the facts, primarily grounded in findings of credibility, or credibility being a major component. And I think that principle has always pervaded these cases. And I don't think any of us were necessarily put off when the Ungerman decision came along in 1991 and Mr. Justice Morton, Chief Justice Morton, then in the Court of Appeal, identified what genuine is, and I refer to that at the bottom of page 1 of my paper, as being a genuine issue, and set out what it is that a court must decide. That is, that a trial is unnecessary, where the burden is. But of course, in that case, there really was a credibility fight about the arrival of a check in respect to a real estate transaction, and the court said that that case should go on to trial. And I think we all accepted and understood that as essentially a clarification, a statement as to where the rule was going. So what I think started to happen, are the doors closed, was that business was building in the Court of Appeal. There were a huge number of summary judgment appeals flooding into the court because the natural reaction of an unsuccessful party, especially on a summary judgment motion, is to take that next hop. And with the deferral that was available because of the huge lists that were running in the Court of Appeal and the backlogs that we had in the mid-1990s and following, I mean, where we are in the Court of Appeal now is light years from where we were 5 years ago. The Court of Appeal was seeing a huge number of these cases coming in. And as you may recall, a practice direction or a practice emerged in the Court of Appeal of trying ultimately to expedite those appeals to get them dealt with early because of the huge tactical advantage to an unsuccessful party in simply appealing the summary judgment and really essentially tossing out the proverbial anchor, tool that none of us have ever used before. And my suspicion, and I don't have this firsthand, is that the Agoni and Dawson and Rexcraft cases very much reflected a policy decision of the Court of Appeal to say enough is enough, that there should be a more sparing use of the summary judgment procedure, and as a result of that, we're going to slow things down somewhat. And as you know, the Agoni case was a discoverability case. Dawson and Rexcraft was a different case concerning a commercial transaction. Dawson was actually decided not referring to another decision of the Court of Appeal called Soper and Southcott, in which the Court of Appeal did exactly the opposite of what Justice Borens did in Agoni. Summary judgment was upheld in respect to a discoverability issue on a limitation period, in that case in a medical malpractice case. And for those of you who were Rule 20 files, it's found at 1998 111 OAC. But it's very interesting to read that case because it lands in the middle of Agoni and Dawson and shows the Court of Appeal going the other way. Now, I say that Dawson and Rexcraft was essentially the high watermark of the statements by the court in respect to the Court of Appeal in respect to Rule 20. And made it very clear that Rule 20 is not court reform or the reform of the adversary system in disguise. It's simply a weeding out process in the clearest of cases. And I've given you a bit of an excerpt from that in the paper. Now, I think that as a policy tool, the combination of Agoni and Dawson had the desired effect. I think the number of summary judgment motions that have been brought generally in the court have fallen off, and I think the number of summary judgment appeals that are being heard in the Court of Appeal have fallen off, along with a good bit of its business, because it's a lot quieter than it used to be, and as we all know, we can get appeals on an awful lot faster. I say that Dawson was the high watermark in respect of the policy statements. A case called Kilpatrick was the high water in discouragement, because that was a case in which, despite the view of the parties that they wished to get the case on to be dealt with on consent, the cost-effective approach taken by the parties was somewhat frustrated on the rocks of Dawson. And I don't know how many of you are familiar with Kilpatrick, but Kilpatrick was a wrongful dismissal case. And this chap had come down to Peterborough to head up the hospital there, and was in the right age group for a rather large award as far as notice was concerned. And the parties brought the action on by way of a summary judgment motion before Mr. Justice Wilkins, agreeing between them that they were content to have the court fix the period of notice. And the court did it, a whopping 30 months. And an appeal was taken, but the appeal was not brought on any principle relating to the Rule 20 jurisdiction. The court raised that itself and said, this is no way to decide an issue such as notice, and concluded that on the principles of Rule 20 as expressed in Dawson and subsequent cases talking about not having a paper trial, that the matter would have to go to trial to assess the proper period of notice. Now, I stand back for a moment and say that is a very discouraging note, because there are times when the parties fashion the best possible way to approach the resolution of an issue. It's difficult to say that a notice period would turn on anything approaching credibility, although the credibility of the plaintiff's case as such would always be a factor. But in the end, one would have thought that the weighing of a period of notice and the appropriate notice in a wrongful dismissal case is as relatively objective a process as one can get into in the course of making a finding in a court. And Mr. Justice Boren said that as laudable as the motive of counsel was, it was inevitable that the motions judge would exceed his proper role on a Rule 20 motion. He evaluated credibility, weighed evidence, and drew factual inferences. Some of the very things that Mr. Justice Henry thought were de rigueur back in 1990, and that he conducted what the court has now criticized as being a paper trial. And that paper trial reference refers to a couple of cases that have come along in the Court of Appeal. One, Transamerica, which I refer to, and the other, Toronto Dominion Bank. And the other is, I'm referring to the Transamerica and Occidental Life Insurance and Toronto Dominion Bank. And that was a case in which Mr. Justice, or Associate Chief Justice Osborne, said Rule 20 is not for the conducting of a paper trial. And that language, paper trial, has now permeated this jurisprudence, that we're not going to conduct a trial based on a paper record, rather we're going to do it in a courtroom. Now, there are others in the Court of Appeal who have tried to temper what may be viewed as somewhat of the swing of the pendulum in respect to Rule 20. And Mr. Justice Finlayson, in a case called V.K. Mason that I've footnoted at page 3 of the paper, had a somewhat different view of the case law. He said Ungerman and a number of other summary judgment cases were recently reviewed in Dawson. Well, I do not believe the court changed the law from that set out in Ungerman. The extensive analysis by Mr. Justice Borens as to the difficulties motions court judges encounter in determining whether the record before them discloses a genuine issue for trial emphasize a restricted scope of the judicial process created by Rule 20. That's a tough message for the court to deliver to trial judges. Dawson isn't a change in the interpretation or the law surrounding Rule 20. I don't think there are many trial judges, motions judges, who have taken Dawson that way. I think that the reaction that I find when I'm there on a motion for summary judgment is I've got to deal with Agoni and Dawson on the paper trial cases and satisfy the court that I have addressed that issue. You can never leave that unsaid on a motion for summary judgment. It just goes with the territory. Another issue with respect to paper trials, it almost leaves the impression that if you throw enough paper in front of the court, if you're a respondent on a motion for summary judgment, that you're in a position of saying, look at all this paper. This is going to be a paper trial. Others have said it's the job of we as lawyers to synthesize cases down to what their essential elements are. But it's a discouraging note as well that the more complicated a case may appear by way of the amount of paper that's before a court on a motion for summary judgment may be the death knell of the success of your motion all by itself, and I'll come back to that in a moment. So, may I offer a couple of comments on the concept of the plenary trial as the mode of dispute resolution in Ontario. I understand the rules of civil procedure to mandate the most just and expeditious resolution of disputes between the parties. That was the policy expressed in Rule 1 of the Rules of Civil Procedure. I don't believe that there are many parties now who can afford the length and complexity of our trial process. It's just too expensive. All of us go through the process of trying to estimate for a client at the beginning of a piece of litigation, what is this going to cost? First off, we're lousy at it. Secondly, we're wrong. And thirdly, it's always more expensive. You ever notice that? We spend all of our time trying to manage our communications with our clients about the cost of the litigation process because there are few people who can afford it. And there are fewer people who view it as a cost of doing business. When we have clients like that, glory, hallelujah, it's a wonderful thing. But it's rare indeed, and we don't find ourselves, in my view, discharging our professional obligations unless we're able to properly advise clients as to the cost and the complexity of trials as a mode of dispute resolution. We have Rule 76 under the Rules of Civil Procedure. It mandates a much less rigorous test for a motion for summary judgment. The court shall grant judgment unless it's unable to decide issues without cross-examination, and it would be otherwise unwise to decide the issues on a motion. Now that's a much more relaxed jurisdiction. If you talk to our judges sitting in the court across the way today, they do more and more and more Rule 76 stuff. And it's working quite nicely, thank you. They're deciding these cases on summary judgment motions. They're dealing with the summary trial process under Rule 76, and it is working. And we don't tend to see the same measure of turbulence, controversy with respect to the interpretation and functioning of that rule. The other thing that we forget our rules have mandated for us are other methods of dispute resolution. That wonderful contradiction in terms, mandatory mediation, is one. We now have a rule that tells us we have to go through a mandatory mediation process in our case-managed cases. The pretrial process, in which there is enormous institutional and policy pressure for us to settle our cases or narrow them. The entire cost structure of the Rules of Civil Procedure, which is designed to discourage us from going to trial without having made a real effort to settle a case. The other element that I say reflects that from the practical dispute resolution point, or from the practical dispute resolution point of view, the plenary trial isn't necessarily viewed as the mode of dispute resolution, is the exodus from our system into ADR, either statutory regimes or in respect of those regimes that parties elect, either by agreement at the outset when they enter into a relationship or as a result of recognizing that there are better ways to resolve a dispute. And I think that the Rule 20 jurisprudence and the language of Rule 20, if it remains the way it is, has been left behind. And the court's allowed it to be left behind, in my very respectful view, from what the forefront is, which is the need for us as practitioners to be able to offer quick resolutions that are cost effective. Now, let me come back to the jurisprudence for a moment, to two other cases. The Lana case a decision of Mr. Justice O'Connor, which I refer to at page 5 of the paper, and one other subject which I've called cost chill. The Lana case was an interesting one because in that case, the moving party relied almost, I don't say almost exclusively, very extensively on that party's examination for discovery in support of the motion for summary judgment. And as we know, the rules permit the use of examination for discovery in respect to motions for summary judgment. And Mr. Justice O'Connor, in deciding that case, concluded that under Rule 3904, you can't use your own discovery in the same way you can't use it at trial to support your case. You're going to have to put in an affidavit and suffer the indignity of being cross-examined upon it. And that's very important because it makes it clear that once again, in respect of a motion for summary judgment, you have to weigh the benefits of putting forward an affidavit and subjecting the person who may be the same witness who was the witness on discovery to a second bashing, and always the potential for two different stories or two different variations coming out. And so we can't grease our way into that motion with our elbows in, as we all like to do, based on using the examination for discovery. The other decision I wanted to refer to is the Smythe decision in the Court of Appeal, and that was a decision in late September. And as we all know but rarely remember, Rule 20.06 subsection 1 says that on a motion for summary judgment, if you're unsuccessful, solicitor-client costs follow, unless the court is satisfied that the making of the motion was nevertheless reasonable. Well, in light of the rather less than helpful statements in the jurisprudence about when you do and don't bring a motion for summary judgment, you can imagine the difficulties one may come across in dealing with whether or not the motion is reasonable or reasonably brought. And Mr. Justice Borens made sure in that case that the unsuccessful party paid solicitor-client costs on, again, a discoverability type case, and made the statement that Rule 20.06 is designed to discourage unmeritorious motions, and concluded from looking at the examination for discovery of the appellant, who was an elderly person who'd had an operation, and the question was, at what point did she appreciate what had gone wrong, and then when does the clock start to run, or ought to have known of the negligence? Concluded that it should have been obvious to the respondent that it stood virtually no chance of success when the motion was brought, or he, in this case, he was a physician, and therefore the costs were awarded on a solicitor-client basis. Well, if you're in that kind of case, a discoverability case, a credibility case, I think you run four square into this kind of language, and you run a real burden, a real risk in respect to an award of solicitor-client costs, which these days, on a complicated motion for summary judgment, can be very significant. So that is one more sort of chilling note. So what does that mean as far as how we go forward in the practice with respect to Rule 20? I think we have to be very cautious in the use of the rule as it now exists, because it is a very difficult type of motion to be successful on. You have to think very carefully about whether or not there is an issue of credibility, or could be an issue of credibility on a genuine issue for trial type test, and as to whether or not you're going to have to ask the court to draw a good number of inferences from the material which is before them, inferences from the evidence, inferences of the type that a trial judge would draw or would have to draw to decide the case in order to be successful. If you are going to bring it, the factum is key. You've got to have a factum which is short and simple. The fact that there's no genuine issue for trial has to cry out from the pages of the factum. You can't do a 35-page factum on a motion for summary judgment, because the more the judge reads, the more complicated it gets, the more inferences leap off the page, the more potential for credibility issues. And so, as far as the material that you prepare, a good, crisp factum. Secondly, pare down the paper. Get it to the absolute minimum. What documents really matter? Don't do the kind of affidavit we tend to do sometimes, where every document ends up as an exhibit on in the affidavit. Cut it down to what matters. When you plead the case at the beginning, plead it with a view to a motion for summary judgment. Don't do a 50-page statement of claim. Do the 10 or 12-page statement of claim if you can. Make it an easy read. And we all know that when we start a case, we should have one mind on how, or one part of our mind anyway, or the mind we use, to how we're going to get this case resolved. And it's extremely important that you think about it in terms of what you draft. If you've got a magnum opus for a statement of claim, forget the motion for summary judgment. How is it, Mr. Griffin, the case suddenly became so simple when you couldn't get it out of your mouth in less than 65 pages? Well, that's an unfair question, Your Honor. Now, I'm of the view that we now have more judicial resources available to us for trials. We have a greater ability to get a case on more quickly for trial, especially the shorter cases. I'm amazed when I go to assignment court periodically and the court says at the beginning, if you've got a 3 or 4 day case, we can do it virtually any time. On the commercial list, if your case qualifies on the commercial list, you can get a trial virtually any time. So you have a great ability now, which we didn't have in 1990, and we didn't have in 1998 when this jurisprudence started trickling out in respect to Rule 20, the ability to get cases to trial as quickly as we can now. So I think before you bring a summary judgment motion, which inevitably means getting into the appeal loop and the delay, and if your judgment's set aside on appeal, you're sort of a year down the road perhaps, 9 months down the road, and you're back where you started. If you can get a case on for trial in 6 months, spend your client's money towards more certainty than getting into the summary judgment loop, think seriously about it, because I think you're better off getting the case to trial if you can. A note on reform. I set out in my paper one direction that the Rules Secretariat had looked at in respect to modifying our rule to permit the court to grant judgment, notwithstanding a genuine issue for trial, if the court, unless the court's unable to find the facts necessary to decide questions of fact or law, or it would be unjust or appear to be unjust to decide the issues on a motion. In other words, sort of broadening out the ability to say, notwithstanding the technical stuff, a la Dawson, this case shouldn't go to trial. That's the Manitoba form of rule. In the discussions I've been having around and sort of on a quiet basis as to where the Rules Committee is going, it seems that they're not really going to go down that road. And my sense is that what they are going to do, and I'm not looking at a piece of paper when I tell you this, is that they are going to broaden out to some degree the ability of the court to weigh evidence, draw inferences, and evaluate the overall credibility of a position, and also to permit the Kilpatrick type of decision that if the parties come there on consent, that the court should have some jurisdiction to deal with that. I think it's inevitable that Rule 20 has to be and will be amended. I think it's inevitable that it has to be broadened out to make it more consistent, in my view, with the policy of the Rules of Civil Procedure. And I think it will once again become a useful tool, but at the moment, I don't think it's all that useful in a broad number of cases. So that's all I have to say. I got to go to court for real, so if you don't mind, are there any questions? Otherwise, I'm going to beat a retreat.
We'd ordinarily ask for questions, but Peter does have to be in court. Perhaps he could take one if someone has one ready to go. Otherwise, you can save your questions for Melissa, who's coming up next.
Thanks.
Thanks, Peter. I just note parenthetically the case that Peter refers to in his paper and his speech, Smythe and Waterfall. I guess is it the most recent decision from Mr. Justice Borens, Peter?
I believe so.
Just about a month ago, in which he chose to, I think, be fairly harsh about the subject of costs, saying that the counsel and parties ought to have known there was no chance of success, that he seems not to have mentioned the fact that the court below granted summary judgment. And, you know, just to echo Peter's comment that if there's anything more chilling than that, you know, surely if you were successful in the first instance, you shouldn't be told that it was clear, could have been clear to anyone that you ought not to have brought the motion.
And you never know before you bring it just how wrong the judge at first instance is going to turn out to be.
Continuing on with our theme, just while Melissa comes up and gets herself organized, I'd like to introduce our next speaker. And notwithstanding the difficulties we as litigation counsel are having with Rule 20 and getting matters disposed of completely prior to trial, which Peter has just dealt with, we still hold out some hope for early determination of issues. And the next topic for this morning is the question of early determinations of questions of law in particular. Because as we know, even if we can't get our whole case out of the way at the beginning of the case, sometimes you can get a significant chunk of it out of the way and achieve some efficiencies that way. I'm pleased to introduce Melissa Kennedy, who is sitting to my left. Melissa is a partner at the litigation firm of Kelly Affleck Green in Toronto. She practices primarily commercial litigation, but as with Peter Griffin, her practice indeed extends well beyond that area, and she acts as counsel in, for example, estate litigation, intellectual property, sexual harassment, and a range of other areas. And so she comes to us as a broad, I don't know if we call full-service litigation counsel and a frequent speaker. And she is going to hopefully tell us how we can get some early determinations of questions of law using some of the rules that are intended to serve that purpose. Thank you, Melissa. And when Melissa's finished her formal remarks, we are going to have a question period. So I'll come up and take questions, and we'll see how time unfolds, but we'll try and get some questions done at that point.
Terrific. Thank you very much. It's a pleasure and an honor to be asked to speak today at the Civil Litigation Forum. What I've been asked to speak on is actually a fairly interesting area that we don't think about too much because it, quite frankly, doesn't happen that often, but when it does, there's a wonderful opportunity for you as counsel to take advantage of a number of choices of procedures that are available to you in the rules. And that's when you have a question of law. A question of law which could determine the entire dispute. That could be what the entire dispute is about, is a question of law. Or a question of law that will preliminarily deal with an issue of your proceeding. So I'm thinking about it in both contexts, where you might have a question of law on an initial part that you want to get out of the way strategically as leverage. Perhaps it may in fact like an injunction, determine the entire outcome, or give you some leverage in settlement. The menu of choices that I'm going to be discussing are an application, summary judgment under Rule 20, in a different context than Peter was just remarking upon, and Rule 21, which is a determination of an issue before trial. And now, I'm not going to go into a lengthy discussion of what is a question of law. That in and of itself is worth another half day, in my opinion. Suffice it to say, and I've just gone through some of the definitions, primarily which to assist you when you're trying to determine whether indeed you have a true question of law or question of fact, I recommend you look at criminal law, because that's in essence where it tends to arise. Questions of fact involve resolutions of factual disputes, the occurrence or non-occurrence of an event. For instance, in the situation of the civil tort of battery, did A touch B? That would be a question of fact. It arises in the criminal context because you see in criminal law, questions of fact are left to the jury, whereas questions of law are in the domain exclusively of the judge. Questions in law involve the interpretation or application of law. For instance, in our example about the civil tort of battery, what is the legal significance of A touching B? and that will be the application of the civil tort of battery to the factual circumstances of that particular case. Now, we also can have questions of mixed fact and law, which gets even more interesting, and these can involve both questions of fact and questions of law, so intertwined that the question cannot be determined without both being answered. It is possible to have in your question of fact scenario, question of law scenario, questions of fact which do not arise from factual disputes. For instance, you may have undisputed facts, a question of law, but in order to get to your particular interpretation of the question of law, you need to draw certain inferences and persuade the trier of fact that certain inferences should be made from the undisputed facts. The drawing of those inferences is in of itself a question of fact. So you can't just always say questions of fact are solely in the domain of disputed facts. That's not necessarily the case. It gets a little tricky, but just to give you a heads up when we're thinking about this. The topic that I'm talking about is the early determination of questions of fact, questions of law. And without meaning to be banal, why do we want an early determination? Well, as we've all experienced, we want to attempt to save some sort of resource, either time, money, or our client's effort. That is the reason predominantly why we want an early determination of the question of law. It may assist you also strategically, as I mentioned earlier, in providing some leverage in ongoing settlement negotiations. Before embarking on a review of each of the three procedures that I've been asked to speak about today, I think we need to understand four different things. And that is, first of all, the requirements that you must have before you can embark upon a particular procedure. So I'll be looking at the requirements of each. The second thing you must understand is the tests that are necessary to be made out after you've decided to embark upon each of these routes, one of these routes. The next thing you need to understand are what are all the kinds of steps or potential steps that can occur in this procedure, and they're not all the same. And the other thing you need to review is the consequences of failure, which can be significant. You need to understand all of these things of each of the three procedures, the requirements, the relevant tests, the necessary steps, and the consequences of failure before you can make an intelligent analysis of which one to choose. Therefore, I'm going to be talking first about the requirements for applications. Just as a backgrounder, that I think is an interesting thing to always keep in mind whenever you're thinking about the rules of civil procedure, and it's a bit of a one of my hobby horses, is that understand the policies behind the rules. There are policies behind each of the rules, even something as mundane as the service rules. There's a policy behind each. And you'll find in applications and summary judgment that there's a tension between two different policies. That being the efficient, expedient vetting of matters, claims, or defenses without a trial. So the emphasis on efficiency, cost saving, etc. The policy that it butts against from time to time, and most notably, as we have seen in Agoni and the Dawson Creek Court of Appeal decisions, is the rights of the litigant to have their day in court. And those are the two tensions that you see in both applications and in summary judgment. It is not present in Rule 21. In Rule 21, the policy of that rule is predominantly the efficient, expedient vetting of matters at an early stage without a trial. With respect to, first of all, applications, matters proceed by action by default unless you can fit yourself into one of the enumerated heads of applications, which is in Rule 14.05 sub A to H. That's at pages 4 to 5 of my paper. You can also proceed by way of application if a statute permits you to do so. And the statute will literally say something like the parties can apply to the court. Anytime you see the word apply, that gives you the statutory right to proceed by way of application. If you have a question of law and facts are not in dispute, then this is a fairly easy situation, and you are in probably the end basket clause, is what I call it, of the Rule 14.05 sub H, the last rule, and that specifically provides for applications without factual disputes. That's an easy situation. I would submit it doesn't happen very often, but it certainly is out there. And it obviously does happen from time to time because the rule is there. If facts are in dispute, this is not fatal to applying to the court by means of an application. So just because you have facts in dispute, you can still go by application, but you must fit in within one of the other enumerated grounds, subsections A to G.1, or have your right by way of an independent statute. So it's not fatal if you have factual disputes. You still can proceed by application if you can squirrel yourself into one of the other grounds. Such as in Rule 14.05 sub 3D, the interpretation of a will or a contract. So that's the requirement. Before you start drafting your notice of application, that's what you must have to even start to think about going down that road. The test that we get concerned about when we proceed by application is, will this application be turned into a trial of an issue? And what that means in Rule 38 sub 10.10, there is the ability of the respondent to challenge the proceeding by way of application and ask for a trial of an issue. The court also, on its own motion, can direct that there be a trial of an issue. So the danger is you have some factual disputes. There are some matters that are factual in nature and there's disputes about. You decide to proceed down the application. You do all the steps, which I'll go through, which are necessary. You get to the hearing. The respondent successfully challenges the application, turns it into a trial of an issue, and you've, in essence, perhaps wasted a lot of time, money, and your client's effort. There are some things which you need to ask yourself when considering the risk of whether the application will be turned into trial of an issue, such as, are there complex disputed questions of fact? Are there issues of credibility which are involved in these questions of fact? So is there a requirement for oral evidence? Now, there's case law to say that just because a respondent stands up and says there's a requirement on a particular issue for oral evidence, that's not fatal to proceeding as an application, but it certainly is a factor that would tend towards turning it into a trial of an issue. And also, does the affidavit evidence before the judge hearing the application set out sufficiently all the other facts, or all the relevant facts for the determination of the question of law, or is there other evidence that's necessary? If that's the case, and you haven't fully canvassed everything and put everything before the court, the judge could well, on his or her own motion, direct there be a trial of an issue. The steps of an application are predominantly the same as with a motion. So I'll just go through it once, and I'm sure you're all very familiar of it. Application is by notice of application as opposed to a motion, a notice of motion. You need to file affidavit material. You need to look at and respond to any responding material. You then have to do consider doing your Rule 39.03 examinations. These are examinations of witnesses pending the application who have not filed affidavits, but whose evidence you believe is necessary. Cross-examinations, answers to undertaking, potential disputes on refusals from the cross-examinations. You can have motions on refusals in both actions and applications. And anybody been embroiled in one of those, you know how long they can take. You have to order, obviously, and pay for your transcripts, prepare your factum, and then you're ready for your hearing. It can be quite a lengthy, involved process depending on how many affiants have filed material and or depending on how many Rule 39.03 examinations that there are. Certainly, if you're thinking about an application as opposed to an action, the work that you've just done in your application, particularly if you lose, could well have been spent preparing for trial. Consequences of failure. Excuse me. Unlike a motion for summary judgment, if you lose the application, it ends the matter, particularly if the issue, the question of law determines the entitled dispute itself. You, of course, there's the routes of appeal, but it's with summary judgment, of course, there's, if you lose at summary judgment, you can always finally win at the end of the day at trial. There is obviously not that available to you on an application, although hopefully you're embarking upon your application with a little bit more bullish attitude that, gee, I've got a second kick at the can if I lose. But that is a potential consequence. There are normal cost consequences if you lose, subject to the Rule 49 offers to settle, formal offers to settle. What I mean by normal cost consequences, there is no specific provision in the rules that if you improperly bring an application, could be awarded solicitor-client costs like there is in the summary judgment rules. If the failure, what I think of a failure of an application, however, is not winning or losing on the merits of the application, more so is if it gets turned into a trial of an issue. That, to me, would be the real failure as far as looking at it from the viewpoint of an early determination. At that point, you have gone through all these steps. You're then at the process now of having a trial of the issue. There may be further examinations. There may not be. That's all part and parcel of the judge's discretion, and it is a discretionary one when directing that there be a trial of an issue. Just a little practice tip, if you're ever in that situation, ask for pleadings. Because when you get to trial, having a trial without pleadings as a result of an application can be a little tricky unless it's made clear that the notice of application is, in essence, the statement of claim. So that's something to be considered. Again, if your matter is turned, from the plaintiff's point of view, if your matter is turned into a trial of an issue, this is extremely expensive, time-consuming, and taxing of the client's efforts. From the defendant's point of view, you have more of a choice if the matter is commenced by application. Or respondent's point of view, sorry. As a respondent, you are in the position on an application to challenge that method of proceeding and say, we should go by action. The reverse is not true. As a defendant in an action, you can't say that this matter should properly go by way of application. So you do have more choice as a defendant if the plaintiff starts off with an application. Summary judgment, once you've looked at the aspects of application, your question of law can also be decided by way of summary judgment. And if it's solely a question of law in Rule 20.04, that specifically provides for the court to make a determination of the question of law. The requirements are not that taxing. The pleadings must have been closed. There is some case law that if you bring your motion for summary judgment prior to discoveries, that affidavit as a document should be exchanged. If, of course, you brought them after discoveries, that will hopefully have already happened. So the requirements for your summary judgment is not that onerous. Now, the test, I'm not going to go into a huge analysis of the test. I listened to Peter's comments, and I agree with them. I think there has been a chilling effect by the recent decisions in the Court of Appeal on the summary judgment. And the problem is, what is the test? When you're at this part of your analysis trying to figure out which method should I go by for my question of law, one of the things you have to figure out is, well, which one am I going to be most successful at? And you can't make that proper analysis or advice to your client until you know what the test is. And unfortunately, in summary judgment, that's a bit of a moving target. There, in my opinion, I think the court has gone too far in the supporting the policy of having the litigant stay in court. I think that is moving contrary to so many other policies that are being fleshed out by rules, mandatory mediation, etc., trying to have a more efficient, expeditious determination of disputes. But that being said, you do have to have some regard to the test of genuine issue for trial. Again, if you have purely a question of law without any factual disputes, it's a fairly straightforward method if you wish to proceed by way of summary judgment. That's not the tricky part. Unless the respondent on the motion for summary judgment is able to raise up enough dust and show that there are factual disputes. But if you're truly in a situation where there are no factual disputes, that's the easy case. The tough case is where your question of law is nestled in amongst factual disputes, some of which are material, some of which may not be material. And that's where the real analysis comes in. Are the factual disputes that are there going to be of a nature or of a significance in determining your question of law that they're going to attract the Boren's chilling effect, as I call it? Or can you stick to the confines and the principles as enunciated by Mr. Justice Morton in Ungerman? It makes it difficult, quite frankly, to advise clients as to whether to proceed by way of summary judgment. Because it is very easy, I submit, for respondents to raise factual disputes. And in particular, I think there's still some room for debate as to really truly how to deal with bald assertions and bald denials. The cases were going along, I believe, fairly happily. On how to deal with them. The case law certainly said that they would take a good hard look, and spurious claims or defenses would not survive. However, we get to Agoni and Dawson, two of their recent Supreme Court of Canada decisions, and Mr. Justice Borens uses language like the court should never assess credibility. And, well, that in my brain seems to indicate that if the respondent raises a bald denial, I could be stopped by a first instance motions court judge who reads that, says, there is a factual dispute here, I cannot look at the evidence, I cannot weigh the credibility, and therefore you're gone. The real problem with summary judgment and the steps, by the way, going through our analysis are exactly the same as an application. The real problem with summary judgment, of course, is the flip side of the feature that there's a second kick at the can. The worst thing, one of the worst things to happen to you is to lose your motion for summary judgment, particularly if there has been lengthy examinations and much affidavit material and perhaps motions on refusals and undertakings, etc. A worse situation than that is losing it on appeal, because then you're right back into it, the trial. So not only, so you could have perhaps tripled your effort in some respects for resolving your client's dispute, which to most clients, or a good deal of them, even if they have deep pockets, they only have so much time and effort. So summary judgment has an advantage. There's a second kick at the can that also very much can be to your disadvantage. Consequences of failure as a plaintiff, as I mentioned earlier, there is the potential for solicitor-client costs in Rule 20.06 of the rules. This is for instances, however, of improper use of the rule. And frankly, it doesn't occur too often where you have solicitor-client costs awarded. Usually you're not so bullish as a plaintiff in bringing your summary judgment motion that you can't make out a credible case that it was reasonable to do so. So it's a risk, but I would submit it shouldn't be high. If it is high, you rethink doing it altogether. The cost consequences of your own client's time, money, and his or her effort can be mitigated by at the final judgment of the summary judgment motion, having understood you've lost, asking for the transcripts from the cross-examinations to be used as examinations for discovery. The judges almost always will do that unless there's a huge problem, and almost always they do that. You just have to remember to ask for it. So that is a big way in which you can alleviate some of the duplication that will inevitably occur when you've lost a motion for summary judgment. Of course, you don't have to worry about that if you've decided to bring your motion for summary judgment after discoveries, which, quite frankly, is a great introduction to the rule. Makes a lot of sense, in my view, to be able to do that now, to rely on discovery evidence. If you don't ask for the court to treat the cross-examinations as discoveries, at least on those issues that were canvassed, you potentially can expose your client to two examinations on the same issue, which can be very damaging. As a defendant, the consequences of failure of as a respondent rather, if you lose on the motion for summary judgment, are that, of course, that ends the matter, and you're stuck with appeal rights. It's easier, however, I would submit, to respond on a motion for summary judgment, especially these days, and defeat it on the basis of the factual dispute creates a genuine issue for trial, than it is to turn an application into a trial of an issue. So when you're a respondent, it's better to see a motion for summary judgment coming if you think you are in danger of losing than it is to see an application. It's just easier to, in my view, defeat the motion for summary judgment, particularly these days in the quagmire. I think that's an appropriate title for Peter Griffin's topic, the quagmire of summary judgment jurisprudence. For summary judgment, if your only question consequences of a failure, it's obviously if the only issue is truly a question of law and you're moving under Rule 20.04, the court finally determines that issue. there's no particular strategy for either the plaintiff or defendant except, who's going to win it on the merits. That doesn't play into it. That finishes applications and motions for summary judgment. I'm going to go through the similar analysis for Rule 21, which is not a rule often used because it doesn't happen very often, to be quite frank. As I said initially when I began speaking, there is no tension in this rule of trying to allow for the litigant to have his or her day in court. In the Rules of Civil Procedure, the rule is described as providing a procedure for determining various preliminary issues which may dispose of the proceeding without a trial. Well, that sounds great. That sounds like exactly what we're doing. Determinations of questions of law at an early stage. However, the requirements are more stringent than they are for proceeding by way of summary judgment. The question of law must arise from the pleadings. It's really kind of that straightforward. They must arise from the pleadings. The question of law must arise from pleadings in an action. Rule 21 is not available to you in an application. The pleadings, therefore, must have been exchanged. So as a defendant, if you are going to move under this rule, you must file a statement of defense. And of course, then you get into a strategy of how to properly plead the question of law in your pleading. You need to look at this very carefully because this is all the court will have. So as a defendant, if you see a statement of defense that raises in your mind a question of law, or it discloses no reasonable cause of action, but primarily I'm focused on it raises a question of law, your statement of defense must carefully be drafted to narrowly be constricted to that question of law. In Rule 21 motions, no evidence is permitted before the court. Now, if you're moving under 2101B, which is you say that the claim has no reasonable discloses no reasonable cause of action, there can be no evidence, period. There's no exception to it at all. If you're moving under the first part of the rule, A, 2101A, there is an exception where parties can agree for evidence to be admitted, or the trial or motions court judge can order otherwise. However, there's a real however caveat. It's not readily granted. The courts will not, in essence, treat a Rule 21 motion as a summary judgment motion by allowing in affidavit evidence. It's an extremely unusual circumstances that are very fact-specific. For instance, if you have, in the pleading, if there's a reference to a document in the pleading, you can refer to that document because that's incorporated by reference. In order to have the full question of law issue before the court, there could be another document that needs to be before the court. That's about as far as you can go. That's about as far as I've seen in the case law that you can go. It is not a general holus bolus summary judgment kind of notion, that exception that you see where evidence is admissible with leave of the court. It's very, very sparingly done. There can be, and the reason for it is, there can be no disputed facts. There's no facts in dispute relevant to the question of law. There may be on some other issue, but relevant to your question of law, there are no factual matters in dispute. So that's why there's no need to have evidence before the court, and that's why there's no tension about the policy of the litigant's day in court, because there's nothing for the litigant to say. there's no factual dispute. The test that you need to keep in mind is consistent with the policy of the efficient determination of matters which don't require a trial. What you need to show the court in order to satisfy that you've properly brought a Rule 21 motion is that determination of your question of law will dispose of all or part of the action, substantially shorten the trial, or result in a substantial saving of cost. That's wholly in line with that policy. And quite frankly, it's generally speaking easy to do to fit yourself in within that test. The problem with the determination of issues before trial is to actually succeed on it, it's got to be plain and obvious as far as what you're asking the court. This is true on both the motion, when you're moving under the Section B, striking out a pleading for no reasonable cause of action, and on the question of law. It's got to be plain and obvious. So you've got to have a pretty high case. Now, the steps are much different for obvious reasons because we don't have evidence. So you have your pleadings, you have your notice of motion, and you have your factum, and that's it. So you've gotten rid of an incredible amount of scheduling and expense and time-consuming steps with this procedure. It's very efficient in that regard. You're solely focusing in on the question of law. Consequences of failure are only significant in as far as, obviously, if you've lost, it's cost your client some time, money, and marginal amount of his or her effort. Cost consequences on the other side, but again, the solicitor-client cost consequences are not built into this rule. So the consequences of failure are not as significant as with the other choices of application or motion for summary judgment, simply because there aren't as many steps. It's really kind of as simple as that. I have sort of thought about different scenarios, and it's really difficult to do this in a vacuum without a specific fact situation. But just to get you thinking of the kinds of questions you need to ask. One of the kinds of questions you need to ask, now that we've understood the requirements, the tests, the steps, and the consequences of each of these different choices is, does my question of law, will it dispose of the dispute between the parties, or is it simply one step within the proceeding? In summary judgment, you're probably aware, but it doesn't happen that often, but certainly it is available to you to move for summary judgment on all or part of the action. So the summary judgment does not have to be the final determination if you've moved on part of claim which involves a question of law. Now, interestingly, in the area of applications, the courts have also tended to move towards the position that your question of law does not need to have a final determination of the dispute. So you could proceed, for example, by application on your question of law, have that dealt with, and then request a trial of the remaining issues. That is potentially open to you. It's in case law. It's not specifically under the rules. It's in the case law that has developed under the application rules, but that is open to you. And it's something that we don't tend to think about, is hiving off parts of our case, mainly because we're under incredible pressures from clients to resolve the whole thing, but quite often resolving a part of it, particularly if it's key, will prompt a settlement negotiation and settlement that's favorable to your client. If your entire dispute centers on the on your question of law, and there's no facts in dispute, and this is not a pleadings issue, so it's not a Rule 21, it would be my tendency, all matters being equal, to seriously think about going by way of application and not summary judgment. This is because to avoid the quagmire that's occurring in summary judgment. Even though this is an area where there are no facts in dispute, so you shouldn't get into all of the nonsense with the test, I would still go by way of application. Your applications tend to be more focused than summary judgment. There's no solicitor-client cost penalties if you do lose. As I say, you avoid a lot of the quagmire from the summary judgment jurisprudence. If the entire matter depends on question of law, so answering your question of law will resolve the matter, and there are also facts in dispute, you can obviously proceed by way of application. But as discussed, the risk will be that the matter will be turned into trial of an issue. Whether or not it will be turned into a trial of an issue is dependent upon the materiality and the nature of the matters in dispute. And here the defendant has more leverage. If you lose by way of application, however, your matter's at an end. At least a summary judgment, you do have a second chance at trial. It's important when you're thinking of any of the choices that you have, and on a question of law, you do have a number of choices in the rules. It is important to understand what are the possible consequences if I lose, if I win. Can the client survive the potential of losing if the consequence is the duplication of time, money, and effort? You must understand the requirements and the tests of each of these proceedings before you make an intelligent analysis of which one to choose. I am finished, and thank you very much. And if there are any questions, just noting my time here. Thank you very much.
I'm going to kick off with a question, and then we'll see if anyone else has one. You made the useful suggestion of, if unsuccessful in a motion for summary judgment, asking that the transcripts from the cross-examinations be treated as discovery for the subject matter that they cover. Mm-hmm. And would not the same technique be available if you commence an application and the court decides it ought to proceed by trial of an issue?
Yes, I think it would. Absolutely.
So just to add one thing to your list of advantages of applications, I was making a little list in your talk. I mean, one theory that you can all think about is whether the effect of the Court of Appeal decisions on the test for summary judgment will be to liven up the interest in proceeding by way of application as a plaintiff. It isn't helpful to you as a defendant because, as Melissa has pointed out, you don't get to make the choice. But as a plaintiff, if you have a factual record which is perhaps not simple enough for the Court of Appeal on summary judgment, but perhaps is, if you took a hard look at it, something that could be done in writing, you proceed by way of application. As Melissa has said, you have the normal rule on costs, so there's no exposure for solicitor and client costs, except if there was a Rule 49 offer. You avoid the law on summary judgment. You ask for your transcripts to be used as discovery if you're unsuccessful, and you end up, if you're unsuccessful, with a trial of an issue. I ask this question. Is the trial of an issue necessarily a bad place to end up?
Not necessarily. The problem, of course, with applications is fitting yourself within it in the first place, and that's the real hurdle. Are you within the enumerated heads, or do you have a statute that assists you to get there? I think you're right. I think there aren't as many, obviously, applications as there are actions, and what's been going on in summary judgment may resuscitate more applications where litigants have a choice of proceeding by way of application or action. I think you're absolutely right, Wendy. There could well be a more proceeding by way of application, because that's not a bad place to end up.
I mean, one of the accepted grounds for proceeding by way of application is to construe an agreement. So if you have a breach of contract case, all you're really doing as a plaintiff is asking someone to construe the agreement to the point that the other side breached it. So that's an option open to you. Now, it may be that you don't get the whole job done at once because perhaps damages can't be dealt with.
That's right, and I think that's what scares counsel. And trying to explain that to your client is also very, very difficult unless they're very, very sophisticated. Is that we're going down this road and we're going to be cross-examined, we've got all this expense and time to do these things. And yes, the hearing we won, but I can't get your dough yet. So that's a difficult thing. I suggest to convince sometimes clients that this is actually a more efficient way of doing things. But I think you're right. I think it is a proceeding that we should look at more carefully.
Questions? Apart from mine? No.
Questions?
I'm looking for questions. No? I might have one more. I might have one more question if I can. I just want to go back to another thing you mentioned, which is the options as compared between acting for plaintiffs and acting for defendants.
Yes.
So if you act for a plaintiff, you can decide between commencing an action, in which case you limit yourself to Rules 20 and 21. Mm-hmm. And Peter talked about the need to have that in mind before you draft your statement of claim and application. But as a defendant, your choices are between Rule 20 and 21, and if it's a claim, or if it's an application, your choices are to defend the application in writing, or to ask that the matter be referred to as for determination of a trial of an issue.
That's right.
So my question is this: as a defendant, when you make the choice, defend the application or ask the matter be determined by way of a trial of an issue, do you have to wait till the hearing of the application to do that, or can you move sooner than that to ask for that to be determined?
I think you can move sooner than that to ask for that to be determined. The real risk is the court's discretion. And that's always a bit of a wild card, because even if the parties agree that the matter proceeds by way of an application, and they've hashed out as between them the feasibility of proceeding by application as opposed to action, the court can, on its own and in its discretion, direct it to go by way of action, trial of an issue.
So that picks up with the comment you made that you could get all the way to the end and end up at the beginning.
You could.
With the exception that if you can take advantage of the work that you've already done.
And I think that's right. I think you can in both cases. So there's ways of doing it in both cases to take advantage of what you've done, as long as you remember to ask for it.
One more chance for questions. If not, we'll have our, oh, good. This gentleman in the blue shirt.
I'm sorry, what about combining?
What about combining any one of these methods with a request to admit? The question, just for the room, is would the response to a request to admit be admissible on a Rule 21 motion?
The question of law in a Rule 21 motion has to be raised in the pleadings. So if you're trying to do an end round around that, it won't be successful. There is no, as far as the facts are concerned on a Rule 21 motion, the facts, the material facts which have been pleaded in the pleadings are assumed to be true. So what the facts really are is irrelevant for the purposes of determining that question of law as disclosed in the pleadings. That's why there's no evidence. So what you see before you in your pleadings is assumed to be true for the purposes of the Rule 21 motion. So I don't see how your request to admit will assist you.
But on Rule 20?
Oh, I think it would be very helpful in Rule 20. And I think that's an excellent suggestion. Requests to admit are not used frequently by counsel, but there's no reason not to. It would be if quite an effective technique if you had the right questions to ask and got the right admissions.
And we're happily going to be having a presentation tomorrow on the subject of making better use of requests to admit, because there are consequences to requests to admit. So it's a way of putting some pressure on the other side.
That's right.
There was another gentleman to your left with a question. Is there still someone back there? Oh, no, it was you. I'm sorry, the lady in the back row. So I think the question is there a way, without going through the entire motion for summary judgment, just to find out that there's a genuine issue for trial at the end of it? Oh, that's in the context of an application. Yeah. Yeah, I think that in the context of an application, I had asked the question, could you get an earlier determination of whether or not you're going to be able to deal with it in writing?
In the context of an application.
Yeah. And I think that's a good point to make, that that's something that's not available to you in motions for summary judgment, but is available to you as a defendant or would be a respondent in an application. Mm-hmm. But I must say that in a motion for summary judgment, the point at which you should perhaps be asking that question is upon exchange of material and cross-examination. You should be always taking another look at the motion for summary judgment to determine whether you should be proceeding or whether you should be doing a deal with your opposing counsel to settle the motion and move on.
I think that's extremely good advice, because you're not going to be in the best position at trial to say, gee, I want this huge amount of cost because we shouldn't have gone this far, and inevitably the judge will or should say, when did you raise this with opposing counsel? So I think that's excellent advice.
Any other questions? So we'll take our morning break. We're starting back up at 10 to 11. Thank you. And thank you to Melissa.